reasons. Number one, I think that everybody needs to know their rights so that they know what is and is not allowed under the law. And number two, I think that lately a lot of people have been relying on whatever they see when they Google things or look at AI. And you need to be really careful. And when you just look at a quick search like that, it's not accurate 90% of the time. This is a very common misinterpretation of the UCCJEA, especially when people rely on oversimplified AI blurbs or Google summaries. You posted a screenshot in the comments that says, yes, a Connecticut ex parte child custody order can be served by a New York law enforcement officer. This is because the UCCJEA allows for the enforcement of custody orders across state lines. An officer in New York can be authorized to serve the order, and UCCJEA ensures the order is still valid and enforceable in Connecticut. That's what your AI screenshot said, and is actually false. And this is why people need to really be careful and check your sources, check your information, and do your own research, and don't just blindly rely on AI. People need to understand what the UCCJEA is and what it means and what it does. The UCCJEA does not equal service of process. The UCCJEA stands for the Uniform Child Custody Jurisdiction and Enforcement Act. What it does is governs jurisdiction and recognition of custody orders between states. It does not and cannot override a state's own rules of service of process, which are jurisdictional and procedural. More importantly, it does not authorize out-of-state law enforcement to effectuate original service of a Connecticut court order, whether they are Port Authority Police, New York Police Department, or a sheriff. So your insinuation that if it had been New York Police, then it would have been legal, and since it was Port Authority Police that it wasn't, is also false, and that's a misunderstanding of the law and a misunderstanding of the UCCJEA. Under no circumstances can any law enforcement officer from another state ever serve an original Connecticut custody order. The only people who are authorized to do that is a Connecticut state marshal. Under Connecticut law, there are strict requirements about who can and cannot serve ex parte emergency custody orders. Connecticut Practice Book, Section 25-28 and Section 4-4 requires that civil process, including ex parte child custody orders, be served by an authorized Connecticut officer or a properly issued foreign commission. For service on somebody outside of Connecticut, such as in New York, the plaintiff must file Section 52-59B long arm statute and potentially obtain a court-authorized commission for an out-of-state service. So Connecticut Practice Book and Connecticut General Statute Section 52-59B is their long arm statute, which says that if my ex had wanted to have me served out of state, he would have had to get a court order to have authorization for a commission to conduct an out-of-state service. What he did was used Port Authority police officers to illegally detain me without any paperwork and without a warrant, and lure my daughter away with peanut M&Ms without DCF present or a parent present, and literally armed men that are employed by the Port Authority Police Department kidnapped Juliana, and it was live streamed and 500,000 people watched it happen. So in this situation, a New York law enforcement can only participate if one, a Connecticut state marshal or process server initiates lawful service procedures, which didn't happen, or two, New York enforces a valid served and registered order, which would usually be a formal UCCJEA registration process under Article 3 of the Act. But none of those things allow a New York officer to initiate service of a Connecticut ex parte order unless it's been validated and domesticated under UCCJEA Article 3. Even the UCCJEA commentary makes this clear. Quote, Nothing in this act shall be construed to alter the requirement of appropriate service of process under the originating state's rules. This is a quote from the official commentary to the UCCJEA, section 105. So the AI screenshot that you had from Google might be confusing the words enforcement and service. And by you saying that Port Authority can't do it, that is correct. But you insinuating that New York PD can is incorrect, and that's misinformation, and people need to understand the law and understand their rights, and these type of comments need to be addressed because people need to understand that original service needs to happen in accordance with the rules for the state where that order came from. And so if that original service never happened, then that order is not enforceable, not until the proper service takes place. And here we are 18 months later, and guess what never took place yet? So what I want everybody to understand from this is that the UCCJEA governs jurisdiction and enforcement, not original service. Connecticut law requires service to be done by a Connecticut state marshal or a party authorized through a court-issued out-of-state commission. Neither the New York Police Department nor the Port Authority Police Department can lawfully serve an ex parte Connecticut order unless Connecticut has properly authorized it, which they did not. And without proper service, any enforcement is unconstitutional and void. You can look at Connecticut Practice Book Section 25-28 and Connecticut General Statute Section 52-59B. And you can look at the fact that I was detained without a warrant and my child was illegally seized by armed men with no warrant and no paperwork, and that was a kidnapping. So yes, it's illegal no matter what, and UCCJEA only applies to enforcement of orders that are already served and in effect. Does not give out-of-state officers the legal authority to serve something in a different state that didn't come from their state. It just doesn't work like that.